Negotiable Instruments Act, Section 45, Partial Failure of Consideration not consisting of money. Section 45 of the Negotiable Instruments Act, 1881 addresses situations where the consideration for signing a negotiable instrument does not consist of money but has partly failed. This provision ensures that, in appropriate circumstances, the liability of the signer is proportionally reduced, provided certain conditions are satisfied. 1. Scope of the provision. This section applies where a person has signed a promissory note, bill of exchange, or cheque. The consideration for such signing consists of value other than money such as goods, services, or property, and a part of that consideration has failed. The value of that failed part is capable of being determined in monetary terms without requiring a collateral enquiry. Thus, the provision is limited to cases of partial failure of non-monetary consideration that can be readily quantified in money. 2. Nature of non-monetary consideration. In many commercial transactions, negotiable instruments may be issued in exchange for goods supplied, services rendered, property transferred, or other forms of non-monetary consideration. For example, a promissory note may be issued in consideration of the delivery of goods, a cheque may be given in exchange for services to be performed, or a bill of exchange may be drawn against the supply of merchandise. In such situations, the consideration does not consist directly of money but represents some other valuable benefit. 3. Partial failure of consideration. Partial failure occurs when only a portion of the promised goods, services, or property is delivered or performed, or when part of it becomes defective or unenforceable. For instance, goods delivered may be partly defective or short in quantity, services may be only partly performed, or a portion of property transferred may turn out to be invalid or unusable. Where such partial failure occurs, the signer of the instrument may be entitled to relief under this section. 4. Requirement of ascertainability without collateral enquiry. A key requirement under Section 45 is that the value of the failed portion must be ascertainable in money without collateral enquiry. This means that the amount of reduction must be determinable directly and easily from the transaction itself, without requiring complex investigation, independent litigation, or examination of extraneous matters. If the value of the failed consideration cannot be determined without extensive enquiry, the protection under this section may not apply. 5. Proportional reduction of liability. Where the above conditions are satisfied, the amount that a holder standing in immediate relation with the signer is entitled to recover is proportionally reduced. This ensures that the signer is not compelled to pay the full amount of the instrument when a part of the agreed consideration has not been received or has failed. However, this reduction applies only in relation to a holder who stands in immediate relation with the signer, meaning a party directly connected in the original transaction. 6. Immediate relation requirement. The principle of proportional reduction under Section 45 operates between immediate parties to the transaction. It generally applies between the maker and the payee, the drawer and the acceptor, an indusser and his endorsee, or any other parties who by agreement stand in an immediate contractual relationship. The provision does not ordinarily affect the rights of a holder in due course who has acquired the instrument for value, in good faith, and without notice of defects. For more details, contact us.